Any mention?
May I please, Your Lordship? My Lord, I beg to mention item number 8. My Lord, if we can be granted some accommodation in this matter. My Lord, if we can be granted 2 weeks' time in this matter.
My lord, I'm here for the corporation here, Respondents Corporation.
What is the matter about?
My lord, they are challenging the penalty electricity bill, my lord.
So any objection?
No, my lord.
And for the state, Your Lordship. State is a formal party.
On prayer of the petitioner, not objected to the learned counsel of the respondents. List after 2 weeks.
2 weeks, my Lord.
Much pleasure, Your Lordship.
Much obliged.
Item number 18. This is a criminal petition involving those married couples under the POCSO Act, which is challenged. The matter is fixed today. Reference is fixed today for hearing.
This is POCSO.
POCSO.
Okay, so we'll have it after 2 weeks.
My lords.
Okay, Your Lord. 2 weeks.
Lordship, I beg to mention item number 3. The similar matter is pending before the Honorable Supreme Court.
Yes, Your Lordship.
Okay, just see the thing. List after 4 weeks.
Same prayer for item number 4, Your Lordship.
That is also pending before episode.
Yes.
Yes, 3 and 4. Both are same. Yes. 4 weeks.
Lordship, I'd like to mention item number 15, Lordship.
15.
Lordship, I'm paying for 2 weeks' time, Lordship.
I am for respondent number 5, Lordship.
Yes.
After 2 weeks, Lordship.
No objection, Lordship.
No. Okay, 2 weeks. 15. All the prayer of the petitioner. Yes.
May I please, Your Lordship? I beg to mention item number 6, Your Lordship.
Yes.
I pray for 2 weeks' time, Your Lordship.
No objection, Your Lordship.
The prayer of the petitioner. Not object to the respondent. Just after 2 weeks. Yes.
Highly blessed, Lordship.
Lord, I beg to make a mention of item 5 of the hearing this morning.
Yes.
No, this case has newly come to me, my lord. So, may I request, my lord, if this is taken up after the vacation?
This case is.
My lord, I will be arguing in this matter, my lord.
I could not follow this. What did you say?
This is a petition under 482.
Yes.
You're challenging, the main ground of challenge is the delay in taking cognizance of the FIR.
Delay in taking cognizance.
My lords, there is a 5-year delay. The law provides that you cannot, certain offences, cognizance cannot be taken after a certain.
Is it not that has to be seen during the trial?
No, my lord, it is something, my lord, there is an express bar under CR.
There's a bar under law.
My lord, there is a bar. Certain offences where the punishment is less than, my lord, a certain amount of, certain period of time.
Yes.
So, I was praying, my lord, if this matter could be taken up after the vacations. my lord.
I have no objection.
You are appealing for?
We are together, my lord.
That's on prayer. On prayer, Mr. KP Bhattarji, Learned G, appealing for the respondents. Not objected to by Mr. Gautam, Learned Counsel for the petition. List after vacation. Yes.
Obliged.
After winter vacation.
Lordship, I beg to make a mention for item 7, Your Lordship. Item 7.
Yes.
2 weeks' time, Your Lordship. 2 weeks' time I have given you.
What is this matter about here?
Is that exports, Your Lordship? Exports matter, Your Lordship. Exports matter. I am seeking for some exemption. From the,
Subsidy.
Subsidy is not.
There's a claim for subsidy.
yes, Your Lordship.
Okay. Yes.
No objection, Lordship.
Just repeat the same thing. List after 3 weeks. Make list after 3 weeks.
Much
Yes.
Lordship.
Lordship, I beg to mention item number 11, Lordship.
Item?
11. Praying for 2 weeks' time, Lordship.
Which other side? Oh, okay.
No, Lordship. Forest.
Okay. One prayer made by Mr. Shandgupta Learned. Additional PP.
Yes.
Appealing for the petitioner state. This is matter after 3 weeks. Yes.
Obliged, Lordship.
Me
Please, Your Lordship. Your Lordship, I beg to mention item number 12, Your Lordship.
Yes.
I've taken consent from my friend. This is a matter regarding...
We do not know, madam. Hearing matters before holiday becomes very difficult because disposal will not be there. If judgment is not passed then and there, then it becomes same. Ultimately, it remains the same thing. What is the matter about? What is
This is
it?
quashing, Your Lordship.
Of
Domestic violence. FIR, they have filed an FIR against
Any
the
interim
husband.
order here?
There is no interim order, Your Lordship.
If you take adjournment, then it ultimately will end up after vacation.
We'll make an
Because
attempt, Your
the court
Lordship.
already has number of matters where
Well, the only thing is here in this complaint, there is no such allegations, specific allegations against the parents. So far as the husband is concerned, I've got nothing to say. But the old parents, one of them is a cancer patient, and every day they have to live with this
who is
tension.
appearing for the private respondents here? Yes. Why don't you settle the matter?
There is no allegation of any domestic violence against the parents, but they have been unnecessarily.
There's an FIR against all of them, the husband as well as the in-laws, by the
And the
private
FIR
respondent.
registers, they're no longer staying, and the occurrence is showing after they have left the residence. So where is the question of domestic
And
violence
this we'll see
they are
when we
not
take up.
deciding?
When we
this-
take
this
it up, Your
we will
Lordship,
see when
because
we take up the matter.
they want a part quashing
Only
of the
my
FIR
parents-
against the in-laws, but the husband will remain. So let us see. We'll have to
Against the
examine that
parents, if
angle,
that
Your
can be
Lordship.
quashed, my lord,
That
otherwise
angle has to be seen.
So when shall we list it then?
if it can be, if it permits your lordship's diary next week, if it is.
See, there is no question of direct. There is no question of hearing the matter. So there is no problem with all
Otherwise,
those.
the whole
The
long
problem is the passing.
winter vacation also they will have to go under that tension.
All
only, my
along, Your
lord.
Lordship, my friend, the petitioners were praying for time. Today, I have
We have
prayed for
never prayed
time.
for time.
You have prayed for time.
So we'll have it after 2 weeks then. We'll just
Okay,
give it a try.
After.
After 2 weeks, we'll give it a try.
The record will show that you are the ones who have been praying for
AG,
time.
Lord and AG, preparing for so-and-so. This is my after 2 weeks.
Oblige, Your Lordship.
May I please, Lordship?
Yes.
Lordship, I make item number 16 also. Item number 16. After about 2 weeks time. Parties I cannot see here. I'll inform them, Lordship.
Item 16. Who is the other side?
Senior Advocate SP Manta, Lordship.
So, no one is there from his chamber.
I cannot find anyone. I'll inform you also.
Okay, on the prayer petitioner list after 3 weeks.
3 weeks.
You inform the other side.
Yes. I'll leave it.
Yes, Your Lordship, I beg to mention item number 17, my lord.
Yes.
My lord, the similar matter is pending before the division bench, my lord.
It's a POXO matter.
Boxing matter.
3 weeks.
Your Lordship, I beg to make a mention of item number 10.
Item 10. Yes.
Praying for 2 weeks' time to file additional affidavits.
Is there an order for filing additional affidavit in this matter? No, not.
They have already filed on the last occasion some compilation. It's already filed.
So why she is making again same prayer?
Maybe she wants to file a fresh one, I don't know.
No, the fresh one means there must be permission by the court. It's a criminal petition, isn't it?
Because one affidavit has been filed on 10/10/25 already. I have received the copy.
What more affidavit you need to file?
We've just received a fresh step, so we need to file some additional affidavits.
Then just wait, let the matter be called up. Then you just make a submission. We'll just see what is the last order.
Oblige, Your Lordship.
Yes.
Supplementary cost list, item number 1.
Yes, Lordship. Petitioner before your Lordship is a senior citizen. We are seeking to challenge the complaint filed before the judicial magistrate under section 92(5) of the Companies Act. My lord, here, my lord, the petitioner, being the owner of a certain property, had only rented the property to a certain company, my lord, who appears to be arrayed as a accused person before the trial court. My lord, your lordship is aware and to have.
You are the
I'm
landlord.
only the landlord, my lord.
And you have given on rent certain portion
Given
of
certain
your
portion
property.
of my property on rent to the specific company who is arrayed as the accused person in the complaint before the trial court. Now, my lord, your lordship is aware under the Companies Act, my lord, to face any consequence for contravention of any provision under the Companies Act, my lord, one has to be a director or any person or any
There is
officer
a complaint by
responsible.
registrar of companies
Registrar of companies.
for violation of certain norms or something.
Certain, my lord, under section 94, failing to file the return, annual return, my lord. Now, my lord, to that extent, my lord, only the officer responsible for the affairs of the company are to be penalized under the Act, or the directors, my lord. I'll take your lordship, my lord, straight to certain
So
annexes.
you
my
are
lord.
not connected with the company.
I'm nowhere connected with either the affair or nor I am a director, my lord, and that their very pleading also says so, my lord. I'll just take your lordship to the complaint directly. My lord, may kindly see page 22. There has been a complete non-application of mine by the learned trial court. First, my lord, page 17, this is an agreement of rent between myself and the company, my lord. My lord, page 17, your lordship.
You are.
I'm Nirmali Kaur, my lord. It's between me and Sun Techno International Limited. Now, my lord, after having executed this agreement, my lord, the company, after a certain period of time, they left my premises without really informing me also. And there are dues as against those company, my lord, the dues of rent. Now, what happens, my lord, is after that, my lord, we came to know that certain complaint has been filed as against that company. My lord, may kindly see page 22.
Yes.
Kindly see the array of party, my lord. The first is the company, the second is.
No, your name is there.
My name is not there, my lord.
First.
My lord, they just wrote it. This is only for the name of my lord, for the sake of, because this company is located in my premises, was located in my premises. Therefore, my name is. I'll take your lordship to another annexure, my lord, which is at page.
No, it's okay. There is no problem. Even if they make you also, unless you are connected with the affairs of the company,
my
you
lord,
will not.
absolutely, I'm not.
No, but then the thing is that
My
your
lord,
name.
may kindly see page 28 once.
Who is appearing for registrar of companies?
But Mr. Devnath was the standing counsel. We have already served a copy on.
Where is he then?
I'm not.
He's not there.
Today he is not available. My lord, may kindly see page 28. This is an extract from the official website of ROC.
Yes.
Now, who are the directors, my lord, as per their own record? K.R. Chatterjee, who is arraigned as accused number 2, Mr. Biswanath Datta, accused number 3, and Dulal Chatterjee, accused number 4. I'm nowhere there.
Yes.
My lord, I'll take your lordship to page 31. Order dated 6/3/2025. I was against me. There was a BWA issued, my lord. For what reason we do not know. I had to appear before the learned trial court in compliance of the BWA. My lord, even me myself being arraigned as a accused person, or my lord, finding my name mentioned in the extract of registrar of directors, my lord, the BWA is issued against me. Whereas, my lord, I have no connection with the affairs of the company.
No, that is, you see, like this array of parties is made in such a way, your name appears to be.
It is there, my lord, but the records will fortify that I have no.
That is a different thing. But the thing is that, you see, initially, until and unless there's somebody to point it out to the trial court,
We had done, my lord, but still, the proceeding is, my lord, the proceeding is proceeding as against me also. My lord, may kindly see order dated 6/3/2025, which you also will find at page 31.
Yes.
My lord, second para, my lord. Counsel so and so appears with Nirmali Kaur and submits that Nirmali Kaur is the house owner where the company has taken on rent. However, BWA was issued against her. In spite of this clarification, the proceeding is still continuing as against me also. But the record will suggest, my lord, and the orders passed therein, my lord, will suggest that, my lord, there's been an absolute non-application of mine by the court, by the learned trial court, resulting in gross abuse of the process of law, my lord. And I'm a senior citizen, my lord. My only fault was, my lord, I had rented
This happened in March. Order is of March, isn't
my
it?
lord. I've been continually appearing, my lord, before the court.
So why?
And in
If you are-
spite of
if you are-
clarification,
if you say that you have no liability there, why should you appear continually?
no, because, my lord, the proceeding has not been quashed or not stayed as against me, my lord. If I don't appear, BW will continue to be issued as against me.
You should have been more active, isn't it, at the initial stage?
My lord, we were initially
There
of the
appears
impression,
that
my
a
lord.
available warrant stands against you. But in spite of that, you are taking rest. This is last order.
No, my lord. I've been continuously appearing,
Last
my lord,
order
trying to implore upon the learned trial court that I have no business whatsoever with the company.
What happened on 28/7? See the page. Please see page 32.
The 28/7, my lord, it's only for the appearance of the other accused and my appearance.
No, then what happened? What is the? We do not know. There
My
must
lord,
be some
the
order.
matter is still proceeding.
By which?
My lord,
your
I'm submitting at the bar, my lord. The matter is still proceeding for appearance of the other accused. And there's been no breakthrough.
Where is Mr. Devnath? You have given me advance copy.
I have already served on him, my lord.
Halt, Mr. Papa. You are a counsel for the petitioner. Issue notice. Returnable in 3 weeks. The petitioner shall take step for service upon the sole respondent within 2 days. Give a paragraph. What is your prayer here now?
I'm seeking for an interim relief for the petitioner only, my lord. I'm basically praying for quashing of the proceeding for the petitioner. And I'm
Yes,
making
if
it
what you say, if it is correct, the proceeding should be quashed. But then there
Absolutely.
must be somebody, I do not know why. And then this trial court order shows that Mr. Devna had taken time to
he
take
had
instruction.
appeared, my lord. He had taken steps against
And
me also.
he had taken time in the month of March.
Right.
And now we are at the end of the year. So how can it be like this?
My lord, in fact, the registrar company has not been able to find the whereabout of these people, my lord. And it's and stuck at that. And I'm being made a scapegoat in the meantime, my lord, in the quagmire that has happened.
This paragraph. With this application, the petitioner has challenged the initiation of criminal proceeding by the CR case number 1090S of 2016. Pending in the court of the Judicial Magistrate First Class Shillong against him in relation to alleged in relation to a commission of alleged offence under the Companies Act under section 92 within bracket 5 of the Companies Act 2013. Stop. Just say, Learned Counsel, the petitioner submits that petitioner has no connection with the what is the name of the company?
Well, the name of the company is, my lord, Suntech.
Where do we get it?
My lord, we'll have it at page 17, my lord. It is MS Sun Techno International Limited.
What is it? It is Learned Counsel petition contains that. With Messrs. Sun Techno Mutual Benefit India Limited, comma, a company registered under the Companies Act, comma, except the fact that she is the owner of the property where the office of the said company is situated. Stop, he submits that petitioner does not hold any position, any official position in the said company, and her relationship with the company is that of a landlord and tenant. Stuffy contents that there can be no dispute to the fact that oh, their building is situated in Assam.
Assam, my lord.
So why proceeding is here? Oh, because the
The
register of
office is in Shillong, my lord.
what do you say? That for the act, for the wrongdoing of the company, only the officials of the companies are responsible. And hence no liability can be fixed on the petitioner alleging violation of provision of the Companies Act, violation of the provisions of the Company Act. Stop. Paragraph. Upon hearing the Learned Counsel and on perusal of the materials of record, it appears that the petitioner is the landlady petitioner is the owner of the property. Where the office of that Messrs. Such and such company is situated. There is nothing on record to show that the petitioner is holding any official position in the company or having any link with the affairs of the company. Hence, from a prima facie it appears that issuance of process against the petitioner in CR case number 1090/2016 by the Court of
JMFC, my lord.
Judicial Magistrate First Class at Shillong is without any legal basis. Hence, it is deemed appropriate that further proceeding in the said case hence it is deemed appropriate, and just say hence. Hence it is deemed appropriate at this stage to suspend the further proceeding of this year case number so and so insofar as it relates to the petitioner. Step. The bailable warrant issued against the petitioner by the trial court shall also remain suspended if the same has already not been executed against her. Stop. List after 3 weeks. You take steps or you can punish him also. There may be some correction on change in the order.
No. Obliged.
Very surprising, isn't it?
Very much so.
Normally, in such a situation, actually, basically, the person who initiate this kind of proceeding must be penalized.
Absolutely.
You cannot subject a person
She's
to
a senior
the rigor of going through the process of law when person has no connection.
Absolutely.
Just see this kind of cases are things. Just see whether there is a provision of penalizing them or not.
No.
If that is what you say is correct. Yes.
Daily cost list, item number 1.
How many?
The same orders in item 2 and 3, my lord, of the supplementary list.
With regard to the same company.
Well, same company, same parties, only the year for which I am being tried is different. There are different three proceedings different.
But then what about the orders? Which
My orders will remain the same, only the CR case number will change, my lord.
the order of the trial court.
Well, same order passed. In fact, it's passed in one order which is made applicable in all the 3 proceedings.
Okay.
Obliged.
Please, Your Lordship.
Yes.
Your Lordship, this matter, the petitioner herein, my Lord, seeks for premature release. He has filed certain application before the respondents, my Lord.
My lord,
And
this is an application for remission, my lord, and lordship has directed me in the similar cases There were 2 or 3 convicts, my lord. She was also...
Now you have a remission policy,
My lord,
isn't it?
yes. It was introduced in January 2025, my lord.
So
Notified.
you have received any application from him?
My lord, we have received the application, my lord. It was June 2025, this year only, my lord.
Yes.
So basically, lordship has directed if this application is received and what is the status. So, my lord, my instruction is that the application has been received by the department and they are considering the application.
But
But my
how
lord,
long will it take to consider? It's received
My
in
lord,
June.
My lord, the procedure is first district judge opinion also has to come in this regard. So basically, the government will take a call only after district judge opinion comes
But
to
then
us.
how long will it take to complete the
My
process?
lord, we'll be requiring some quite a long time, my lord. Yeah. At least 2 to
Then
3.
what is the purpose of remission then?
My lord, because the opinion hasn't come,
If
my lord.
see, after applying, if a person is to remain in custody for wait for the outcome of that application for 2-3 years, then what purpose it serves?
My lord, as per the the policy which have been introduced by the government, the state government has to take a call within 30 days. That is after the opinion of the district judge comes into.
And how long the district judge
My
or the
lord,
session judge
so
takes
far as the
normally?
district judge portion, my lord, I do not have any information, but that will be quite important for us to take a call, my lord. First, the opinion only has to come, my lord. Only if thereafter, my lord, state will be taking its call, my lord.
So, but then when it is expected?
My lord, insofar as whether the application has been
You
forwarded.
filed an affidavit, I
My
think.
lord.
You filed an affidavit stating how long it will take.
My
My
lord,
lord.
Yes.
my humble submission is that, my lord, with respect to the submission of my learned senior, my lord, I have learned that, my lord, in this matter, the petitioner, my lord, has filed a remission application since the year 2023, my lord. And his name, my lord, his name was always eligible in the list, my
This
lord.
is there in the writ petition.
No, my lord, I have learned, my lord, that is in the internal file of the respondent, my lord.
Is it
But I
correct?
have learned.
No, my lord.
My lord, I can bring that on record, my lord. I can bring that on record.
Bring
My
it
lord,
and
yes,
then you
that
make
will be better,
submission.
because we
Without
have no
making
nothing
it
on
part of
record.
record, how you can make submission?
My lord, I have learned it specifically, my lord, since 2023, my lord. And moreover, my lord, his name was always there in the remission list, my lord.
Let her bring the
So
list
you
also,
bring
my
all
lord.
those materials on record. You see,
Yes.
here the learned GA might not know all those things. If
My
you
lord,
give this
yes.
material, that will help your cause.
My
You
lord.
are not here to fight, you know. You are to bring relief to your client, isn't it?
Yes, my lord.
Now,
Yes,
if you
my
give
lord.
her those related, all those related papers, she can help you advancing your cause.
My lord, yes. Since we have a
A
remission
government advocate
policy.
doesn't stand up, always stand up here to oppose.
Yes, my lord.
Then
But my lord, in spite of that, my lord, but still the state is
you
refusing, my
bring
lord.
these all those things on record. She will not
Yes,
know
my
all
lord.
those things until and unless you bring it on record.
Yes, yes, my
You can do it by filing an additional affidavit, but then anyway you do it to your thing. We'll just allow her to give her some time to file an affidavit. Yes, on prayer made by our colony learned GA appearing for the state respondents. Come on, 2 weeks time is granted for filing affidavit in opposition. You first have those materials in your hand and then subsequently bring it on record.
Yes,
You
ma'am.
should have made all those things a part of your writ petition. Why you did not make it?
My lord, those, unfortunately, my lord, those was not present with the petitioner,
If
my
something
lord.
is not there on the record, how can you make an argument basing on those matters?
But my lord, that
The
is
court
not
will be
as
in
per
dark, the other
assumption, my
side will
lord.
be in the dark, huh?
But that is not as per my assumption, my lord. As for factual aspect, which I will place, my lord, on record.
A lawyer doesn't argue anything from his or her personal knowledge. It's to argue on the basis of the materials only.
Yes, my lord.
Item number 2.
My lord.
this matter, Mr. Keshav Gautam is appearing for the petitioner, Lordship.
Oh, this is a matter where FR has been submitted.
Yes, FR submitted.
But then
They have been given opportunity
they want
to.
that thing, the investigation to be handed over to some other.
Now, Lordship, here I have received the information from the IO that the court has passed the order directing the IO to conduct further investigation. Lordship.
Yes.
Yes.
We have reply to the show cause against the FIR, Lordship.
You filed your reply?
Yes, Lordship.
Where?
Before the CGM in Vilamnagar.
Yes, and then what happened there?
No information has been received yet, Lordship.
And you said that you have the information
yes,
somewhere else.
I have received
I think your objection has been, we do not know, of course, what the learned subject. You verify it. We'll just. So what is to be done then?
This matter can come up after 2 weeks, Lordship.
The court has directed for further investigation.
Then your purpose is
But
served,
that
then you can
this
close
order also, Lordship, the court has passed this order without taking consideration the materials and record, Lordship. Only on the basis of their objection, the court has passed this order.
whatever it is, but then their very purpose, for the time being, is served. Investigation will continue.
So let Mr. Gautam appear.
On prayer midway, Mr. Tika Sangma.
Yes.
Learned Council.
JM Sang. JM Sang.
Tika Sangma Learned Council appearing for the petitioner. We'll have it.
1 week, Lordship. 1 week will do. Only two, because the court has already disposed that matter, objection. Let them obtain that order only.
Yes, Lord.
We'll have it after 2 weeks. We'll just see. You have that. Because you may have to see the order also.
Yes.
Only instruction may not do. They may see. One semester. Okay. 2 weeks time is good. For obtaining necessary instruction in this matter.
Item number 10.
Yes, Your Lordship.
Yes.
Lordship has already heard this matter,
Yeah.
my lord. But here,
How many matters this court has heard? Just tell us. Is there any unheard matter left?
no, my
Yeah.
lord. No, but
Your,
the
Your
question, my
Lordship,
lord,
this matter pertains to the nomenclature, which is Honorable Court, the nomenclature as to how a review is maintainable before this court. So I would satisfy. Am I audible,
have
Your
filed an
Lordship?
application by way of revision, my lord. My contention before the honorable court was, my lord, that the appellate provision is provided under Rule 30 of the Administration of Justice Rule. Thereafter, my lord, there was a query from this honorable court, my lord, saying that whether assistant judge has the jurisdiction or has the power to exercise original jurisdiction as the subordinate district council court. My lord. Only to that extent, my lord, now we have to satisfy whether the assistant judge has the power, my lord, to exercise original jurisdiction, my lord, as that of the subordinate district council court. To that effect, my lord, I just have this notification. I just wanted to place, my lord.
You've given, supplied a copy to the
I have
House.
already given the soft copy, my lord.
Your Lordship, I also have the copy of the notification.
So the notification reads, my lord, if I may be permitted.
Just a minute. That is not the notification by which. Tell us where this post of assistant judge is provided in the rule.
It is not provided, my lord.
Then,
Your Lordship,
then
that I agree.
how this notification comes to your rescue? We want to see that what is this court of assistant judge and where it is provided.
Your Lordship, may I
How
take?
appointment is made in that of the position
That
of assistant judge.
this is the only notification which
We
I
want
could gather.
counsel
My
for
lord.
the district council. Oh, where are they?
They were here, my lord.
We just basically probably previously asked for their help also, isn't it? In that.
Yes, but they are only relying on this particular
Mr.
notification, my
Paske,
lord.
this
Your
notification
Lordship.
comes in. This doesn't answer the query.
Your
proposed.
Lordship, I have seen the. Yes, Lordship. Lordship, I would like to take your Lordship to the Garo Hills Autonomous District Council Acts and Rules, the Green Book, Your
Yes.
Lordship. Your Lordship may come to page 71, Your Lordship, Rule 5. Page 71, Rule 5, Your Lordship.
Please, 70.
It's at page 73, Your Lordship.
Yes.
Page 73.
Yes.
Your Lordship, this is the constitution of the court.
Exactly,
So
Mr. Paske. We have noticed that thing, and that is how the query came from.
There are three courts, Your Lordship. There are three courts out here: village courts, subordinate district council courts, and the district council court, Your Lordship. Your Lordship, then I'll take Your Lordship to Rule 21, Your Lordship. That's at page 76, Your Lordship.
Yes.
Your Lordship, Rule 21, may I read, Your Lordship?
Yes.
Rule 21 reads as, a subordinate district council court shall have original jurisdiction in all suits and cases in which both the parties do not fall within the local jurisdiction of the same village court, but within the areas under the jurisdiction of the subordinate district council court, also in cases and suits referred to it by a village court under Rule 18. Now the next, it's added by an amendment. So the subordinate district council court and the additional subordinate district council court, as the case may be, shall have appellate jurisdiction in respect of all suits and cases tried by village courts.
What you are trying to point out,
Your
Mr.
Lordship.
Paske? What you are trying
Now,
to point out?
Your Lordship, I want to point out that the order that has been passed by the district council court, not by the subordinate district council court.
That is
because
all right.
there
That
is
is all
no
right.
subordinate.
We'll come to that thing. Just before that, what we want to determine is that where this the court of assistant judge is mentioned in the rule.
It is not mentioned, my lord. I'll
So
concede to that, my
then
lord.
which way we equate this court with
Because
the,
in Rule 7, my lord, if Rule 7 prescribes, my lord, that each court shall be presided over by a judicial officer appointed by the district council with the approval of the governor, and the judicial officer shall also act as recorder of the court.
yes.
So the The assistant
Does it
judge,
mean
as
that-
of now, my lord. No, that is my submission, my lord. The assistant judge, as of now, is exercising the power of the subordinate district council.
See, Mr. Momin, can a person be appointed in a non-existent position? They have the power to appoint anyone.
Yes,
But then to the post which are in existence.
yes, my lord. I do agree, my lord.
Then
So that is why now every order is being passed by the assistant judge, not by the subordinate district
so
council.
that is where just where from we just where
Now they are
from
only
that body-
referring to Rule 11, my lord. Here, as Lordship has already seen.
We want a council of district council, otherwise it's very difficult to
In
comprehend.
fact, this is just a
And
nomenclature, my lord.
until and unless the statement comes from there, then them we would be in difficulty to ascertain the jurisdiction exercise, the kind
Your
of
Lordship, there is
jurisdiction exercised by the assistant judge.
Lordship.
Because here prime
there is
contention
no
is that-
subordinate district council.
that against an order passed by assistant judge an appeal rise.
Yes.
And then by allowing the principle of law, revision will not be maintained.
Yes.
That will be accepted once we say
Yes.
that this assistant judge is equivalent to presiding officer at
Yes,
subordinate district council court. Isn't it?
Yes, yes, my lord.
So then which way we come to that conclusion? We cannot just go on our assumption, you see, or mere submission, until and unless there is something.
Yes, my lord.
Okay, or
No,
even
because I've talked with the council, standing council, my lord. That's the only notification he's also having, my lord.
no, that is with regard to appointment of somebody in that post.
Yes.
But then where from that post came, that is the main thing. And we, especially if it is not ascertained also, at least there should be something showing that what is the type of jurisdiction exercised by the court of assistant judge.
As per my knowledge, my lord, this no.
It has to be in writing.
Yes, my lord. Yes,
That I can
understand.
understand.
Yes,
You
my
see, with this court, you see, as such, may not disagree with your submission which you are making at this court. But then to record a finding,
Yes.
court needs something.
Yes, my lord. I do agree, my lord. I think that'll be district council will be the better
Yes.
position, but
Who is appearing for the district council?
district council
Oh,
nobody is appearing, my lord. I
He
think
is appearing for, you are appearing for the petitioner.
he is appearing for the petition.
So Mr. Paske is there. So, yes, Mr. Paske, what can be the solution?
Lordship can
Your Lordship,
fix another date.
these were the
call for
two-
district council, my lord.
these were the two judicial officers who were looking after the subordinate district council court. As of date, as per the rule also, if I go for an appeal, that would be only by an order passed by a subordinate district council court. But since they are already appointed by that notification
See,
itself,
see,
the
see,
district
see.
council court,
See, in absence of any clarification in the rule,
absolutely, yes.
how do we come to a finding that court of assistant judge is a district council court or a subordinate district council court or additional subordinate district council court? Which way we come to that finding? Isn't it? That has to be specifically provided in the rules.
It's not there in the rules, my lord. I do agree, my lord.
It's not in the
Then
rule.
there must be some notification, something making this court equivalent. Otherwise, how?
Because every order, my lord, original jurisdiction is been exercised by assistant judge only, my lord. Till date. My friend will not disagree with me. Because every order, my lord, which is before
Because
the Supreme Court also,
there was never a
is by
question
the
of
assistant
dispute,
judge.
Your Lordship.
Now, are you see, like, can we say that this both the parties do not dispute the fact that the assistant judge is exercising the jurisdiction of?
Yes.
If you say that, then that things will become simpler for us. But
is,
then,
my lord.
see, that you have to be careful about that. You see, and then
But
we
because
would-
if my friends say otherwise, my lord, because other cases, it's different.
Your Lordship, without
Yes.
having the knowledge,
we are not concerned about the other
I
cases
cannot
right
make
now.
this statement over the bar.
Okay. And the lawyers have different ways of tackling a situation.
Yes,
you
my
see.
lord, I do agree, my lord.
So,
So, but
that is,
so like what
Mr.
has come
Paske
out from
also
your
will be very
lordship, my
much
lord,
aware
I
of that,
feel in order to be fair, my lord, I think the view of the district council, I think
that is needed. You see, otherwise we have to call for certain things from the district council itself clarifying that position.
lordship. So if lordship records on the next day, if district council can appear and apprise this honorable court,
Yes, Your
that
Lordship.
will
There was, so far as this court remembers, Mr. Day was informed about that.
Yes.
Probably. Or maybe his junior, Mr. Deb.
yes.
So see, either of them, you see, but then I do not know. They should have taken this matter. Since district council is not a party here. Have we passed any such order asking district council?
No, no, not yet, my lord. So if lordship, if there's an order, my lord.
You are the
for
respondent here,
clarification.
isn't
I'm the
it?
respondent,
Mr.
sole
Paske is
respondent,
the
my lord.
petitioner. Are you saying that, Mr. Paske, that this no appeal is maintainable against the order of the assistant judge?
Yes, as per the rules, against the order of the assistant judge, district council court. If it would be a subordinate district council court, yes, an appeal would have been maintainable, but not against the order of a district council court,
What is the
judge
provision?
of a district
What is the
council court.
provision of appeal here?
Provision of appeal, my lord, it's rule
Rule 30, Your Lordship.
30.
Where do we get it?
Page 79,
yes,
my lord.
Yes, yes. No,
Page 79, Your Lordship.
no.
An
Let's
appeal
go
shall
on.
lie to the district.
There lies a whole problem. See, he is assistant judge district council court.
Yes.
Then district council court is basically an appellate court, isn't
Yes.
it? So how come he became?
Appellate court.
Then this very exercise of jurisdiction by this court is in nullity. The order has to go then.
But lordship should also see, like, if this order goes, the other order goes, my lord. In view of this
See,
order, my lord.
the consequence will follow.
Yes.
See, the court should not be bothered about consequences.
Yes, I understand, my lord. I leave it to your discretion, my lord, because as
See, this is a serious issue, Mr. Momin. See, we cannot just be callous in passing the order.
yes, my lord.
We have to see the pros and cons and how this assistant judge district council court is functioning. See, there are three categories of court, isn't it? District
Yes,
council
yes,
court, subordinate district
Yes,
council court,
village
additional
court.
subordinate
Yes, yes.
district council
Yes,
court,
ma'am.
and down where there is a village court, isn't it?
Yes.
Now, if it comes to classifying this, the court of assistant judge, then it will classify it as what? The nomenclature says the district council court.
Yes.
Then, and it says an appeal should lie to the district council court. Doesn't say lie to the judge district council court or the assistant district council court. So whoever says his jurisdiction as a district council court becomes an appellate court.
Yes, Your Lordship.
Yes, my lord.
And then the court of assistant judge is not provided anyway.
Yeah, it's not provided, my lord. That I agree, madam. If lordship seeks a clarification from the district council, I think they'll be the better person to answer that query, my lord. Because as of now, since
Okay.
That would require an amendment, Your Lordship, then.
We do not know what would happen, but then amendment cannot be retrospective amendment, Mr. So that even that
Yes.
if there is a defect in excessive jurisdiction, this cannot be corrected by subsequent amendment. And there has to be some solution to it. Heard Mr. Pascal, learning counsel for the petitioner, and also Mr. Momin, learning counsel. There is only one respondent.
yes, I'm the
FA
sole
for the
respondent.
Stop. The next paragraph. The challenge made in this petition is against the impugn order dated. The challenge made in this revision application is against the impugn order dated 25/4/2024 passed by the learned assistant judge, district council court, Garo Hills Autonomous District Council, entitled suit number 1 of 2012. And the revision application has been preferred. This revision application has been preferred by invoking Order 6 of the Meghalaya High Court within bracket jurisdiction of our district council courts, Order 2014, read with Article 227 of the Constitution. Stop. Mr. Momin the learned counsel appearing for the respondent has challenged the maintainability of the revision application on the ground that the order impugned is appealable under provision of
Rule 30, my lord.
Rule 30 of the
Garo Hills Autonomous District
District Administration of Justice Rules. Page 71.
Administration Justice Rules 1953.
Yes.
The rules may be called. See, you'll get it in this book. Red flag mark page. Just tell me the last line. Mr. So and so has challenged the of and hence no revision to rely. Stop. How the submission has been countered by Mr. Pasque. By contending that an appeal under the Rule 30 of the rules would have been maintainable had there been an order passed by either the subordinate district council court or the additional subordinate district council court. Stop. The order under impugned, the order which has been impugned in this petition is passed by the assistant judge, district council court, and as such, no appeal is maintainable under Rule 30 of the rules of the above. Stop. Perusal paragraph, a perusal of the Garo Hills Autonomous District within bracket Administration of Justice Rules 1953 would show that will show that the courts constituted under the rules are broadly categorized as number 1 small Roman village court, comma number 2 subordinate district council courts, and number 3 district council court. Now this also has been printed as 4.
No, sir.
There are 4 eyes, small eyes.
Yes, my lord.
Stop. While the Just make it shorter. Just what is this? There are three kinds of courts. Then, okay. Then the next line, have you sentence? Have you started? No. Okay. Do not say while. Just say. However, the rule does not specify as to whether the court of the assistant judge, district council, is a district council court or subordinate district council court. Or a village court. Stops. None of the council appearing for the parties are also in a position to clarify this aspect of the matter. Give a paragraph. In the event above situation, it would be appropriate to seek assistance of the learned standing council appearing for the Garols district council. The learned counsel for the petitioner. Yes, Mr. You have to take steps. Huh? Learned counsel for the petitioner
Yes, Your Lordship.
shall take steps to inform the standing council for the district council. What is it? The learned council for the take steps to for the district council about this matter and to request him to be present before this court when this matter is taken up next.
Watch.
Stop. Wait for list after 2 weeks. Just see, we do not know. There has to be some solution.
Watch.
Just try to apply your mind. Just try to find out something.
Watch. I'll do that, man.
This is
Yes, Your
a
Lordship.
situation.
Yes, my lord.
Mr. Pasque, also, please.
Yes, Your Lordship. Yes, Your Lordship.
This will be quite difficult.
Yes, my lord. I do understand, my lord. It's a tricky situation, my lord.
The only thing is that this comes from the council for the district council, and if none of you are you have any kind of dispute, then only probably we may hold it to be equivalent to presiding officer subordinate district council court or something like that. That's not.
I'll have it.
Deeply obliged, Your Lordship.